This video just surfaced down in good old Jacksonville, showing a Jacksonville sheriff's officer slapping a 29-year-old man during a traffic stop. And it's now under review, according to a statement from the Jacksonville sheriff's office.
Yo, bitch, that man, that's some more.
Stop pushing against us. Pushing against us. Stop.
Yeah, bro, you ain't got to hit him, bro.
Stop resisting. Yes, sir.
Bro, man, I don't give a came for that shit.
Bro,
Ain't doing nothing. I'm watching you cocker, bro.
They didn't want to take somebody to jail.
Stop. Just stop.
Look.
Get out of the street.
Look.
Stop.
According to the arrest report, the Jacksonville Sheriff's Office said that Dewan Ellis was driving a dark-colored Nissan Altima on Canal Street in Jacksonville when officers noticed he didn't stop for a stop sign. The report said that Ellis turned west on 13th Street and an officer witnessed him drive through another stop sign. The officer then pursued Mr. Ellis and then pulled him over. The officer told Mr. Ellis why he was being pulled over and asked to see his driver's license. While the officer was talking to Ellis, according to the police report, he smelled burnt marijuana. Surprise, surprise. The officer then wrote that he learned that Ellis's license was suspended last year, and he asked him to step out of the car. The report then said that the officer asked Ellis if he had a medical marijuana card, and that he replied that he does not smoke marijuana and does not know what hemp products are, which is strangely specific. The report also said that Ellis was asked to step out of the vehicle and face the car so that the officer could search him. That's when the officer said that Ellis began to physically resist by turning his body. Another officer stepped in to help restrain Ellis and placed his arms behind his back. But the man continued to resist by tensing his arms and pulling away. Once the officer placed Ellis in handcuffs, keyword there, they began the search. The report said that Ellis then continued to resist. But the report did not mention them slapping Mr. Ellis in the face. But in this video recorded by a bystander, you can see exactly what happens.
Yo, bitch, that man, that's some more.
Stop pushing against us. Pushing against us. Stop.
Yeah, bro, you ain't got to hit him, bro.
Stop resisting. Yes, sir.
Bro,
Man, I don't give a came for that shit. Ain't doing nothing. I'm watching you cocker,
They
bro.
didn't want to take somebody to jail.
Just stop.
Look.
Get out of the street.
As you probably just observed, the officer can be seen slapping Mr. Ellis in the face, and it's around 23 seconds into this video. And he's repeating as he does it, "Stop pushing against us and stop resisting." Of course, police officers are trained to make themselves witnesses in their own favor. While the person may not be resisting, they're saying stop resisting because they're fabricating evidence to use to justify whatever use of force they engage in. So Ellis was arrested and charged with resisting an officer without violence, which is ironic, driving with a suspended license, and 2 counts of running a stop sign, and he was released the following day. According to the Jacksonville Sheriff's Office information website, the resisting officer without violence charge is listed as time served, the suspended license charge was dropped, and the 2 counts of running a stop sign are listed as invalid. When the media reached out to the sheriff's office, they came back with the following response. "We are aware, and it's being administratively reviewed, and as such, we are unable to comment further." This was in response to the video going viral, at least locally. What is the law here? Well, this is an excessive force issue, so the amount of force used by the officers will be judged with an objective reasonableness standard, using basically 3 things to guide us. 1, the severity of the crime at issue. 2nd, whether the suspect was actively resisting arrest or evading arrest. And 3rd, and most importantly, whether or not there was an immediate safety threat to the officers or anyone else because of the actions of the suspect. Florida is in the 11th Federal Circuit, and I went ahead and looked at some of the case law on this. There's a good case from 2009, Sanchez versus Hialeah Police Department. I will put this all at the blog post. They, in that case, deprived qualified immunity from police officers under similar circumstances, and they, in turn, in that decision, went through prior cases from the 11th Circuit, which is controlling precedent in Florida, where police officers were found to have committed excessive force under similar circumstances. Some of the cases that they went through, one in particular is very close. Galvez versus Bruce, 11th Circuit, 2008, allowing an excessive force claim to proceed where an officer slammed into a concrete structure. An arrestee who was suspected of having committed misdemeanors was handcuffed, posed no risk of danger or flight, and offered no physical resistance. Or Reese versus Herbert, 11th Circuit, 2008, allowing an excessive force claim to proceed where officers beat, twisted the arm of, and applied a pressure point technique, and sprayed with pepper spray an arrestee who was suspected of having committed a misdemeanor, did not pose an immediate threat of harm, and was not actively resisting or evading arrest. Or the Hadley case, allowing an excessive force claim to proceed when an officer punched in the stomach an arrestee who was handcuffed, did not pose a danger to the officer, and was not resisting. Or the Lee case, these are all 11th Circuit cases, 1998, allowing an excessive force claim to proceed where an officer slammed into the hood of a car an arrestee who was handcuffed, not posing a threat to the officer, not posing a flight risk. So as the Sanchez versus Hialeah Police Department case notes, where you have somebody who is pulled over for some sort of minor misdemeanor, such as running a stop sign, and where they're handcuffed, and where there are multiple officers present, there's not going to be much leeway for the officers to use violence or violent physical force against somebody. There are these cases I mentioned, and there are more that warn police officers that they will be denied qualified immunity if they engage in that behavior. So you can see why these officers are trained and in fact do lie and say stop resisting, even when people aren't resisting, because they're trying to meet one of those gram factors there, or several of the gram factors, by lying. But fortunately, this was caught on video, and we can see that the guy is handcuffed and not resisting. I mean, the officer can say that he felt him tense up or something, but whatever resistance is being offered has to be just completely minimal. From a civil rights lawyer's point of view, any case where you have on video a police officer using violence, even if it is just a slap or a slam on the hood or whatever, against somebody who is handcuffed, I mean, that's going to be an easy case. It really is. For the reasons already listed, because you have all these prior cases saying that that's bad, and police are not allowed to do that. Then the cops will say, yes, but in my experience and training, handcuffed people can still be dangerous. So that can be true, and that's why we have courthouses. That's why we have juries to when there's a dispute over facts, where there's a legitimate dispute about whether somebody's dangerous, or was a threat, or was resisting, or was fighting, or evading, or whatever, where we have a factual dispute. That's why we have juries, to look at the witnesses, to look at the evidence, and ultimately make a decision. Where we have it on video, where the person's not resisting and violence is used against them, it may not even make it to a jury. That's a situation where it very well could be possible where a judge says no reasonable jury could even make that finding, and just not even allow it. Just allow a jury to decide, well, what are the damages? I also want to thank Jeff Gray for sending me this, because he's like my go-to source down in Florida, and in Jacksonville in particular. He's on top of the Jacksonville Sheriff's Office. Please subscribe, both here and at the blog at thecivilrightslawyer.com. Follow me on Twitter, John Bryan ESQ. Also Facebook, John H. Bryan, Attorney at Law page. Remember, freedom is scary. Deal with it.